The following program is suitable for general audience of any age.
Tonight, we discuss the salient features of the Land Development Ordinance as well as recent updates made to the laws surrounding this area. Is the legislation up to date or are more refinements necessary? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty here on Other Derana News Channel, where we bring to you key legal concepts and break it down for the layman. Now, today's topic is something that we should have breached upon much prior because we have done quite a lot of property law related segments, but we haven't been able to get the proper insight on it, especially considering the recent amendments that came about as well, and that's on the Land Development Ordinance. How exactly does this piece of legislation work, and what exactly are the salient features of it is what we're trying to understand here today, along with the current developments on the legislation in itself. And to do so, we have a very well suited individual for this program. We are very glad to invite onto the program Mr. Chathura Galhena, the Secretary of the Bar Association of Sri Lanka. Thank you very much, sir, for taking the time out of your busy schedule to actually come to the studio and help us understand this concept. Apart from being the Secretary of the Bar Association, Mr. Galhena was also the examiner and lecturer for property law from 2012 to 2023, spanning over a decade at the Sri Lanka Law College as well. So safe to say, when it comes to the theoretical aspects and understanding, we're in a very good position to get that kind of understanding. So how we're going to be approaching this topic is, first we'll be getting into the fundamentals. What exactly does this legislation entail? Next we'll be getting into the practicalities and the current context along with the amendments coming in. And finally, we'll be talking about potential reforms and changes we can expect to see when it comes to this legislation in the future.
Hello, my name is Sapni Vijayatunga and I'm a law student at the Royal Institute of Colombo. My question is on fundamentals. What laws govern the land development in Sri Lanka?
All right, well, without any further ado, let's get right into this discussion. So thank you once again. We have quite a lot to cover, but hopefully we can get as much ground covered in this segment as possible. To start off, so before any of the technicalities, if you can help us understand what exactly the Land Development Ordinance is and why exactly it was introduced into Sri Lanka's landscape.
Yeah, as an approach to the topic, Anuradha, I will just go through the tenure of land in this country. As you are well aware that our land tenure drastically changed with the British getting the control of our country. If we take 1815 as a landmark year, by that time the British came and invaded and we became a colony. There was no proper ownership of land, therefore the land ownership was scattered all over. Even the British monarch did not have any land in this country because the 1815 convention, where the country was given to the British to rule, did not contain anything with regard to the land ownership. Therefore, the tenure of ownership was very uncertain. But in 1840, there was a ordinance, or the first piece of statute was introduced called Crown Land Settlement Ordinance, where it was enacted to identify the state land which owned to the crown, which owned to the private parties. In that there was a lot of lands which were not cultivated or not utilized at that time were vested with the crown. I am referring to the crown, the British monarch at that time. So a lot of land in the area scattered. If I say, for example, if I nominate the areas, the Rajarat area, that is Anuradhapura, Polonnaduwa districts, and also the districts like Hambantota, where there were not much population at that time, were vested with the state. And also the Badul and Noreli districts. Because in 1818, we had a struggle by the natives against the British monarch, and by that time, Uwellasa Kerala, and because of that Kerala or the armed struggle, the Uwa province or the Vellasa became unpopulated. So people living there moved to other areas. So because of this, those lands were not occupied and not cultivated. So British wanted to take those land under their control. So they brought this piece of legislation where any land that has been not been used, not been cultivated, not been occupied, were vested, automatically vested with the monarch. So by that, the British got huge amount of land all over this country. To have that land utilized in a more effective way, just few years, at least about 10 years before the independence, they wanted this land which were with their control to be given to the people for development. For that purpose, they brought this piece of legislation called Land Development Ordinance in the year 1935.
So from 1935 to now present day 2026, there has been quite a few changes that
certainly there
has undergone. I think we can get to the updates that this legislature has gotten into. But before that, I'd like to ask you, sir, specifically relating to the application of the Land Development Ordinance. Now we understand how it came to be. What exactly is its practical application?
Yes, the statute itself says it provides for systematic development and alienation of state land. Alienation is also there, development and alienation. Alienation means the state land to be alienated to the private parties. So basically, the scheme is that there was a provision or the scheme introduced for the state land to be alienated to the private parties, not for money but for free of charge for development. So once it is being given to a private party, it is being governed by the provisions of the Land Development Ordinance. How it should be given, how the party should be identified, how the alienation is being done, how the alienation is being going from generation to generation, the land to be occupied in which way, alienated in which way, inherited in which way, all these things are in the statute. So it is being counted. Once it is being identified as a land given to a private party by the state under the Land Development Ordinance, all its affairs will be managed, governed and controlled by the provisions of the statute.
Yes. To get to the specifics in understanding, of course, we get that there is a lot of control that is provided via this legislation in order to ensure that there is a proper distribution. But I want to ask you, sir, relating to who the parties are that when considering the statute itself, where exactly does it concern? Which parties are coming into play when it comes to the not just the development of land but also the divulging of it, the alienation of it? What are the parties?
No, it's like this. Now under the Land Development Ordinance, it says there's a word called kacheri, which is being used in our day-to-day land. Even in the English word terminology is the kacheri. It says any state land to be alienated only through a kacheri. So the word kacheri is being defined in the statute. It says a procedure followed. It's a procedure followed for the public, with well notice to the public, to identify who wants land. So I'm here, I am in Colombo, you are here, we can't go and just claim land in Anuradhapura, Polonnaruwa. There should be people who need land. So basically at Kacheri what they find is there are a lot of illegal occupants in this state land. They want to identify who are they, who are these people, and to give the identified blocks of land for these people to have a proper title and proper inheritance, give a recognition for their possession. That is the mode it happens. So if I just take a step further, the procedure is first to identify by giving public notice. This kacheri is a thing that you give public notice. Anybody who is in occupation, who is in need of land, can go and apply for it. And once you apply, the government agent those days, and today is the divisional secretary, we call it Pradeshya Lekam. Divisional secretary is the person who is in charge of it. He holds an inquiry. On his recommendation, initially a permit will be granted. We'll discuss about it.
Yes, exactly. I want to get to the procedural aspects as well that's stated in the legislation.
Yes.
But before that, I want to make some understanding on the distinction of lands governed under the LDO, the Land Development Ordinance, and privately owned land.
Yes.
If you can give us some clarity on that.
Yeah, it says, now before this statute was brought in 1935, that I told you, Crown Land Encroachment Ordinance as well as Land Settlement Ordinance, which was enacted in 1931. The statistics says that at least 4 to 5 million plots of lands were identified as settled. That means they were identified as whether it is a state land or a private land. As I told you, Anurag, the first challenge for the British rulers was to identify which are private land and which are government or state land. So without identifying what is exactly the state land, you cannot alienate or develop or anything to do that. So the first century or almost a century they have taken to identify which are private land and which are state land. So when it is a private land, it doesn't cover by this. State land, not only, this is not the only statute by which the state lands are governed. This is one of the main, or I will say the key statute, but there are some other statutes as well which govern the state land. Forest ordinance and things like that are there. This is a land statute where state land are alienated to private parties for the purpose of development. So if I directly answer your question, the difference between a private land and a state land, the private land, basically the ownership is governed by the Roman Dutch law, because the Roman Dutch law we don't have a land law of our own. That means the British did not introduce any direct law relating to land ownership. Therefore, the principles of Roman Dutch law applies. But when it comes to the state land alienated through the LDO, the Land Development Ordinance, it is governed by the statute. So it is strictly the statute. We will go on the discussion how it inherit, how it alienation, development, controls, conditions, all these things are associated with the lands coming under this. But for the private land, it is not. Under Roman Dutch law, there are few rights that I can do whatever I want on my land as long as it is legal. I can't do illegal things, but I can enjoy it, alienate it, I can fragmentate it to whatever the amounts I want. I can do anything. And the inheritance also is on the general law. But when it comes to the lands covered under the LDO, strict or a methodical scheme is there. So it will govern by that. That is the difference.
Very important, sir, that you mentioned that the authorities with which these two types of lands are governed will differ. Now, on that note, so specifically on understanding LDO governed lands, you mentioned Kacheri. Yes. There's also this question about permits and grants.
Yes.
I think it's best if we can get some clarification relating to that matter. How exactly are the two differing under this statute?
According to the statute, it says when you identify a person is in a need and he is being recommended that he should be given a land, he should be given a permit. It should start with a permit. The permit defined in a particular section 19.2 says it's an annual permit. So if I am being entitled for a permit, I'll be given a permit for 1 year, where I have to pay the annual fee and I am allowed to legally occupy the land. It may be the land I was previously legally occupying, or maybe a non-occupied land. Once it is been given, it renews annually, and this permit will convert into a grant. Permit is something that I will get a temporary license to live, cultivate and occupy. And there are a lot of conditions that is associated with it. And also it is essential that the fee or the annual levy has to be paid. If my ownership does not comply with any of these conditions, or if I do not pay the annual rates or the annual fee, I am disqualified to get a permit. So it's always after the Kacheri, if you take the chronology, there's a Kacheri, in the Kacheri you identify, then you give a permit. Permit may be 1 year, 2 year, 3 year, we don't know. Sometimes it takes ages, but yet it will convert to a grant. Once it is a grant, it's a different tenure. Permit and grants are different.
Yes, before we get to the grants, since chronologically we can get to the understanding of it, can you help us further understand what rights is entailed when it comes to having a permit issued for lands under the LDO? Yeah,
now once a permit is issued, as I told you, it's an annual permit. It keeps on renewing as long as you are there, and as long as you are paying the annual rates, it will be renewed. Every year the division secretary does not issue you with a new permit, doesn't issue, right? There is no such scheme. Once it is issued, it will keep on renewing. So there are conditions. You can live, you can cultivate, you can develop, and most importantly, your inheritance is decided. So there's a scheme of inheritance which we will discuss further. This inheritance scheme will apply equally for the grants as well as permits. So say for example, if the permit holder dies before getting the grant, the scheme applies. The scheme we will discuss in detail because that is a very important scheme which is drastically different to the inheritance of property in our general law. So that has to be discussed. But if a permit holder dies before getting the grant, the law will apply. And his heirs or either nominee or the heir in the scheme, I will tell you, because it's not heirs, right? In general terms, we call heirs because the thing is, if a person dies, it will go to the heirs. But here it's only one.
A nominee.
A nominee or the person in the table.
Right.
Yeah, I'll refer to the table, what it is in the table.
Exactly. Before getting down into specifics for the permit and how exactly the inheritance scheme actually works, before we get to any of that, just to establish the distinguishing features, how exactly does a grant differ when it comes to a permit? How long? I understand that, as you mentioned, there are years that it takes for a grant to be created. How exactly does that process work, sir?
The law is that when a permit is issued, there is no time limit. It's an annual permit, but annually it keeps on renewing. The grant under the LDO is issued under the hands of head of the state. At present, it is the President of the Republic. President of the Republic issues under the signature. So it's a document that is given from the head of the state. From periodically, there were different names, Jaya Bhumi, Ran Bhumi, Swarna Bhumi, different names are being used. That is the name that has been attached during that particular political eras, but it is the LDO grants. Once it is a grant, it has to be now. If you don't pay the annual rates in a permit, it automatically cancels. And there is no assurance being given once you have a permit, you will get the grant. If you breach any of these conditions, you won't get it. But grants are different. Grants is like, it is good as much as a deed that you get from in a private land. But there are conditions, there are limitations, there are special conditions applied. But it is as much as good as I would say it's better, because thing is document from the head of the state and nobody can dispute. We call it the first class title. It's a first class title where you can use it for all the purposes that you are using your private land, including alienation, mortgaging, taking loans on that, lease.
So mostly similar to privately owned lands, but as I understand, as you mentioned, there are certain
conditions.
Yeah, certain conditions.
Different in certain aspects, but generally it is as good as a title deed.
Yes. I want to ask you, sir, on the specifics on the eligibility for a grant and also the extended process on both permits and grants. As you mentioned, there's quite a few more that we have to discuss. But before we get into any of those specifics, we do have to take a short commercial break. We'll be right back after this on Law, Land and Liberty here on Other Than the News channel. Please stay tuned.
Hello, my name is Himadya Sidmi and I'm a student in Gautam Balika Vidyalaya, Colombo. So my question is, on the current context, what are some practical issues relating to the LDO?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Chathura Galhena, attorney at law, the Secretary of the Bar Association of Sri Lanka. We were just discussing the fundamentals when it comes to the Land Development Ordinance and its salient features. Thank you very much, sir, for the previous segment. I believe with the limited time that we have, we were able to cover quite some ground. Now, building upon the previous segment that we had, specifically relating to the differences between grants and permits. When it comes to the transferring of land under the Land Development Ordinance or mortgages, anything related to transactions with land, how exactly does the landscape play out, specifically stated out in the statute in itself? How different is it between grants and permits?
Yeah, a permit is something that you cannot transfer. Condition itself says it's not transferable. Only thing that will happen is if the permit holder dies, it will go under the scheme, as I told you, or to the nominated person. We'll discuss about it in detail. but its grant is different. Grant is an instrument which is transferable. But the difference between a LDO grant and a private land is that if it is a private land and it has an inherited right attached to the ownership, which we call the right to alienate. I can sell it to anyone as long as that person is willing to buy and I am willing to sell. The LDO, under LDO grants, it can only be transferred with the permission. It's not the consent, it's the permission of the divisional secretary. Divisional secretary must give the permission, give his permission in writing, and it has to be attached to the transfer deed. So generally there won't be a new grant issued under the hands of the president of the country. The original grant will follow because there is a registry which is like the land registry, but it is not in the land registry, but it is in the divisional secretary's office, where there are folios like the books which the registration will keep going. So it will be registered and it's like a normal deed to the notary's right and execute with the witnesses and the provisions of the notary's ordinance. But only thing is there should be the written permission given by the, it's not the consent, it's the permission given by the divisional secretary of the area. Permits you can't transfer like that. The rationale behind this is it is being given to a person who has been identified as a person who is in need of land. And this is the land of the state or the public, and is given free of charge. You are not being paid, you know the value of the land, and these are given free of charge. So you can't just sell it, and then there cannot be undue enrichment. I get a state land free of charge and I can't sell it to a third party for the value of the land, because that is undue enrichment. I am getting something free of charge from the government and I am getting income out of the sale proceeds. That is not allowed. That is why the permission will be there, but there may be illegal transactions happening under the scheme, but scheme is to secure that the identification of the real land needed people, and for financial needs they should not alienate it to third parties.
Speaking of financial needs, the encumbrances that have been put on a land under the Land Development Ordinance makes it so that getting bank loans against such lands is considered quite an arduous task, most probably sometimes improbable. What exactly is the rationale behind that specifically? How exactly is it encumbered in that way?
Earlier also it is possible. Earlier in the sense, there was an amendment introduced in 2022, a few years ago. Even to mortgage or to give as a security to a bank or a financial institution, earlier, before 2022, the permission of the division secretary was required. But by the 2022 amendment, considering the development of the economy, that part was removed. So now a grantee, we call the grantee, a person holding the land on a grant, can mortgage it to a financial institution, commercial bank, or another state or a private bank without the consent or the permission of the division secretary. That is allowed now. So the next step is that if that person is defaulting the loan, bank can take, even the parate can be taken now. There is no legal embargo, because there was a discussion whether parate execution should not be given to state land, because ultimately the owner is the state. So all those things were now cleared. It is considered as a private land when it is recovery is concerned. There's no distinction.
That is actually a very interesting point as well that I want to get understanding on, specifically relating to, now what we have been speaking about is of course the active transfer of lands, while the permit holder, the grant holder is actually in good sense and is able to carry out such transaction. But what exactly happens posthumously, sir, if you can help us understand?
Yes, that is the most, I think in this statute, one of the most important things that we need to discuss is the posthumous thing, that is after the death of the grantee or the permit holder. What happens? If we distinguish that with the general law is that if a person dies without a last will, it will go on the general inheritance. That is, if that person is married and having children, half of the share goes to the wife, half goes to the children in equal shares. If no children, it will go back. It will go back to the parents, sisters, like that, sisters and brothers. It is the general scheme. that scheme does not apply in the LDO inheritance. In LDO, there's a schedule which says it will go to one person. That priority list was earlier given in with gender specific. Earlier it was said number 1 is sons, number 2 is daughters, then grandsons, granddaughters, then father, mother. Likewise, it's always the male get priority. So, over the time gender equality came and we don't distinguish male and female like in those days. So, in the 2022 amendment, these sons and daughters were categorized into one called children, then grandchildren, then parents, then siblings, then likewise it goes. The difference here is, say there's a family with 5 children, 4 girls elder to the youngest. Earlier, all the 4 will go off and this youngest son, who is the last born in the family, will get the priority because it says sons. So the daughters, who however much they born earlier, will not get priority. But under this present scheme, it doesn't say. It is the priority will be given to the, not the priority on age. So eldest in the family, irrespective of the gender, will now be entitled to inherit, subject to there's no nomination. If you want to know about the nomination, we'll discuss it.
Yes, I think since we're on the topic in itself, I feel like it would make sense for us to understand how exactly the nomination process works. Can you help us understand?
Yeah, one more thing, I must tell you that this relationship, it says it should be on blood or on adoption, not on marriage. So it is, if a child has been adopted, he gets equal rights as a child born to the family. It says on blood relationship. And it specifically excludes the relationships created through marriage. So in-laws does not get this priority. So it is always the grandchildren also the same. You might have half blood children.
No spousal.
No, spouses' rights are different. I must specifically tell you, since we are in the topic, I'll tell you. When the permit or a grant holder dies, nominations, inheritance will not apply, will not be effective as long as the spouse is living. The surviving spouse will get the life interest. It is very important. The surviving spouse will not get the title. They will not get the all rights of the permit holder or the grantee. Will be having the life interest. The rationale is that, say for example, a person dies leaving his wife or husband, and if that is given to the children, you know what's happening in our country, there are a lot of issues with the deed of gifts and things like that. So to overcome that, the surviving spouse is given the life interest until the death. Life interest is until the death, the scheme of inheritance or the nomination will not come into effect. That is valid. It is very important to know life interest holder cannot make fresh nominations. Say the father gave the property to a particular son. Then after his death, the mother gets the life interest. She can't change that. She is only the life interest holder. That means she can hold to the property until she lives. She cannot be expelled. Nobody can challenge her right to occupy, possess and develop the land.
So in turn it prevents fragmentation
as well, and also it prevents a social problem. There are a lot of people who claims that once the property is given to the children are not looking after them, then they have to go and live in elderly homes and all these things. So those won't apply because surviving spouse cannot transfer also. She can renounce her rights, but she cannot transfer.
So renouncing is possible, but
renouncing is possible. Renouncing is possible for anyone, even the nominee, even the person who is entitled for inheritance. Anyone can renounce.
I think a very important point that we understood there, sir. Now to divulge a little bit more into that, specifically relating to the amendments that have come about. As per my understanding, the biggest reforms that we saw that were made under the Land Development Amendment was on the posthumous sections and the inheritance areas.
Yes.
Are there some key areas that you could highlight for us to see as the biggest changes that were made?
There was a dire need that because of there were a lot of cases in the courts where one son or daughter, one child, we'll say a child, is with the parents, develops and cultivates, looks after the parents and do everything Others are married and gone now, some are far away places. And ultimately when the parents dies, the eldest son from nowhere comes and get his inheritance. So the person who was in occupation for ages, looking after the land, developing the land, will be expelled. So that was a very common thing that has happened over the past. So this need was identified. So to address that, even though the scheme was amended to gender neutralize the thing, called sons, daughters were not distinguished, all our children, all our parents, all our siblings equal. In addition to that, this scheme or the nomination will not apply if the person who develops the land is a different person. He gets the priority. And also one more thing, the person who nominated, or the nomination also, I must tell you one thing, the scheme provides for nomination. Earlier also that was there. So technically speaking, earlier it was the eldest son, now it is the eldest child who will get it. But if the mother or father prefers that I should give it to another child, or not to a child but to the grandson or granddaughter, they can nominate, and nomination must be registered. Nomination cannot be a alien thing, and that means somebody from the next village or your friend's child, that is not allowed. It has to be from the scheme, but out of the scheme priority, you can pick up a person and nominate him. Important thing is, upon the death of the grantee or the life interest holder. So if there's a grantee is dead, or the life interest holder, the person who nominated or the person who entitled under the scheme must take possession of the land within 6 months. If you don't take it within 6 months, it amounts to waiving off your right, or renouncing your right. So it is very important that within 6 months you take it. And the present scheme is that that person who developed get priority over all others. But he cannot be an alien. He has to be under the scheme. So he may be the youngest child. He get priority. That is the need. That has addressed a long-standing need to give recognition for the person who possess and develop the land.
But again, an emphasis on they must be included in that scheme with blood relation.
Yes, it should be in the scheme. Cannot be an alien. And also, another, you ask a pertinent question about fragmentation. You know, now under our law, as I told you, if there are 5 children and the parents died without leaving a proper scheme, it will go as 1/5 to each. If it is a 1 acre land, then it's 1/5 of an acre to each. Then they have children. Likewise, it fragments and ultimately comes to nothing. But in this scheme, you can't fragment. That is why this is for the development of agriculture and economic development. That is why the fragmentation has been stopped. But under the new scheme, if there are more than 1 child who has jointly developed, you can fragment and give. It is not all, but who are developed. It cannot be all the family occupying. So, but it's like 2 children, out of the 2 in the family have developed. So it can be divided half and half and give. That is allowed. But generally it is for 1 person to get it and develop.
So I want to get to what we can see as changes introduced, but also what we can expect to see in the future now. Considering the fact that there were consistent updates and amendments to this piece of legislation, there is always a question of whether it's already addressing all the required needs, or if there are lapses that are still yet to be addressed through further amendments. But before we get to the specific reforms that we should be talking about in the future to come, we do have to take a short commercial break. We'll be right back with the final segment here on Law, Land and Liberty. Please stay tuned.
Hello, my name is Uttara and I'm a student in St. Sebastian Convent, Kandana. My question is on future. What reforms can we expect moving forward?
Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Chathura Galhena, attorney at law. We were discussing the features of the Land Development Ordinance and the practicalities of it. Thank you very much, sir, for the previous 2 segments. Unfortunately, we are running out of time. But related to the previous segment that we were very much in discussion of the pertinent areas that have been amended and changed, specifically relating to, now we spoke about the posthumous actions that can be taken and the schedule that must be followed when it comes to nominations as well. But in understanding the cancellation aspects for lands given under the Land Development Ordinance, if we could get some clarity on that aspect as well, what exactly is the procedure there? Is it differing very drastically with grants and permits? Because of course, as you mentioned, there is a fundamental difference. How exactly does that work?
There are two regimes for the permits and grants. Permits are can be cancelled at any time on the breach of any condition, or it automatically cancelled if you don't pay the annual rate. But grants are not like that. Grants are given forever. I mean, in the sense, it is given for, it goes from generation to generation. It's like a title deed that you have. Earlier there was a scheme, very cumbersome scheme, which is not easy. That scheme makes it impossible to implement cancellation. And there are a lot of cases I came across. There were errors made by the surveyors or the division secretaries when they give the land. I mean, permit, the land occupied or given under the permit has been changed, because the scheme is, or rather always the scheme is, it is only a conversion of the nature of title, permit and grant. I must tell you one more thing. If there is a nomination made under a permit and after that a grant was made and no nomination was made, there were a lot of cases earlier decided by the Supreme Court as well as the Court of Appeal that nomination made in the permit will transfer. So the basic norm is that the permit is converted to the grant. It is nothing that given in new. You have been given a permit, thereafter it was converted to a grant. So there are a lot of instances where errors has been made. This cannot be corrected. The people has to voluntarily return their grants. Then only after returning it has to be cancelled and given new grants. So it is impossible. Sometimes then they have to come to the court. Nowhere other than the Court of Appeal can give that order. Division Secretary has to summon if they don't honor this, and it's a cumbersome procedure. But under the 2022 amendment, if there's a fraud, error or misrepresentation or anything associated with intentional misrepresentation, the president himself can cancel the grant. Once it is cancelled, it can be given to anyone. Once it is cancelled, errors can be corrected. You can't correct the errors in a grant without cancelling it. So the scheme is that it has to be errors, misrepresentations or frauds.
So a very important point there as well, the ease of which cancellation can occur now to prevent a very tedious process. Specifically when relating to the amendments that we saw as well. So we were able to discuss quite a bit of it, but we weren't able to cover most of it. In your understanding, so what are the key areas that you saw changes brought about when it comes to the amendments that we currently have? And of course, moving forward, we can have a discussion relating to where exactly the lapses still lie and if we are still up to date.
But actually the requirements that mainly we had was with regard to this gender inequality, which from the beginning we saw something unfair is there. Thereafter about the cancellation, thereafter about the person who occupies and develops, as I told you, they were overlooked. So all these things were looked into and was addressed by the 2022 amendment. More or less I would say now those needs have been addressed, but yet there are still the cases coming to courts very often, because the reason is that the persons who are taking the decisions about this possession are state officers like Grama Nildaris and the divisional secretaries and other regional government sector officers. So there can be instances of biasness, there can be instances of giving wrong or erroneous reports. You have no recourse other than going to a court. So people from Anuradhapura, Polonnaruwa, Hambantota, all these people has to come to Court of Appeal. And because there was a judgment delivered in 2014 that under the state land, regional provincial high courts does not have any jurisdiction. So you have to come, you are compelled to come to Colombo. So it's a cumbersome procedure for them. It's cost a lot. You have to retain lawyers from Colombo. You know how difficult for those people. So it has not been stopped. I experienced a lot of instances of filing cases by people even after these amendments. Amendment is very clear. but there is somewhere there's missing the faith on the people on the way that it has been happening. So people still keep on challenging. If you have faith on the officers who are doing that, you won't go and challenge. So when you don't have the faith only, you have faith on the system of justice and you come to court. So that actually when the amendment was brought in, we thought it has been addressed, but now I find that with the day-to-day practical experience that people are still not confined to the scheme that was newly introduced. They still say, no, he's not the one who developed, I developed. So those are factual matters. Somebody, Grama Niladhari and others give the report. So those are very personal bias matters. And I think how that should be addressed is a matter that has to be decided by the legislature and experts. But I think that also has to be addressed, because taking these people for every every death, every transaction to courts is also not a very healthy practice.
Yes, and a very important point. I think that the most important area to address was mentioned just now a few moments ago. So as a final question, I'd like to ask you, with your experience and understanding of this legislation and also the practical experience you have around this, can you just give us some sort of clarity or insight into whether we can expect to see reforms and developments in that specific area that you mentioned when it comes to lapses? Is there communication at the moment?
No, at the moment I think after 2022, LDO amendments were not in discussion, and also on that nothing is, the statute has been amended. I don't see any way that it can be amended further. Then it has to be somebody like a judicial officer to decide. So you can't do that, because it's the Grama Niladhari and Division Secretary who are doing these things, and they are public officers. I'm not saying they are doing wrong things, but the people still challenge those, saying that it is not correct. So either the scheme must be overlooked, there must be supervision by somebody in a different level, or something like that has to be addressed. But I'm saying presently most of the cases that comes to Colombo get dismissed because these public officers has done the correct thing. But I'm not saying that they are doing the wrong thing, but people does not have the full confidence over the decisions that were given.
So there is, while the statutory requirements are met and the legislation looks like it is quite not lacking in most areas and encompassing most situations, when it comes to practical difficulties, splitting hairs, there will be some sort of...
Like any law, it's
yes, of course.
It keeps on continuing with the lapses.
Yes, law in theory and law in practice.
And also one final remark, when it comes to land ownership, people are very personal. In our country, it's very personal, you know, that's why even for small portions of land, they litigate for ages. So maybe because of that they are coming to court, not because they don't have faith on the system, but they just want to satisfy themselves, saying that even the court recognizes my right or my negative right or whatever. So exactly. That is so our blood attached so much to the land ownership.
Yes, definitely. Unfortunately, that is all the time that we have for this discussion. So thank you so much for taking the time. We were able to cover as much as possible in the limited duration that we have. We really appreciate it, sir.
Thank you very much, Ananda, for inviting, and also I thank your TV channel also to giving this, dispersing the knowledge to the public, and thank you very much.
All right, well, we leave you tonight with the words of Aldo Leopold. We abuse land because we regard it as a commodity belonging to us. When we see land as a community to which we belong, we may begin to use it with love and respect. That's all we have for you tonight on Law, Land and Liberty. If you missed any of our programs, always rewatch by catching us on our YouTube page. And of course, please send in your feedback to us through email at feedback.adncenglish@derana.lk or via WhatsApp at 076 805 7933. Thank you very much for watching. Have a good night.